Hi, this is Mohammed Akram. We are here today with the wonderful team, and we are going to explore all these SEC enhancements regarding the regulations which are going to affect soon for the private investment fund. And I have a team here. Start introduction with Steve. Anthony. Steve, go ahead, please.
Sure. Hello, everyone. Steve Rosen, Senior Manager at Akram and Associates on the audit side.
Hey guys, Anthony Masha, Managing Partner EFSI. We run and operate a privately held fund administration firm that focuses on hedge funds and private equity funds.
Simon.
Yeah, hi everyone. I'm Simon Rivelis. I'm an attorney at Rivelis Wahab. We're a boutique firm that focuses on formation of all types of private funds and representing management companies to funds.
Awesome. Thank you, all of you. So just to do some housekeeping items, obviously the people who will answer 3 out of 4 questions will get the CPEs, and after this webinar in the next few days, a week, we will send you your CPE certificate via email. Okay, let's get the ball rolling. So as you guys know that on August 23rd, 2023, SEC implemented heavily anticipated private fund reforms or rules under the 1940 Act. Although these rules are very less mandate driven than those originally proposed in February 2022, but these rules are nevertheless very impose significant disclosures and requirements that all private fund advisors should consider when forming new funds or offering new offerings to the existing investors or in the existing funds. So overall, I believe that the SEC has passed 2 rules applicable to all managers of pooled investment vehicles, regardless of the registration status of the manager. They are prohibiting 4 preferential treatments, and they're also putting 5 types of restricted activities. We may not go over all of those, but let's take a big picture from Simon Rivers what these rules are. And I believe there is some lawsuit is being undertaken by US courts against the applicability of these rules. So Simon, floor is yours.
Yeah, thanks, Mohammed. That's right. These rules were adopted a few months ago and were published a couple weeks ago in the Federal Registry and will go into effect in either 12 or 18 months, 12 months for registered RIAs, SEC registered, and in 18 months for non-registered managers of funds. The original proposal a few years ago on these private rule changes was hotly contested by the industry. Many of those rules didn't go into effect, but a number of them did. And they apply differently to registered and unregistered SEC advisors. One of the areas that the SEC focused on is transparency of side letter agreements. So going forward, beginning again on the compliance date in 18 or 12 months, any preferred terms that have been entered into or provided to an investor in the fund in question at any time during the fund's existence will need to be disclosed to both existing investors in the fund beginning on the compliance date and any new investors in the fund. And then going forward, any preferred term that arguably disadvantages the fund or investors in the fund would need to be offered to all investors in the fund. And then there's certainly ongoing granular fund level performance reporting that is more granular than has been required in the past, including itemized expenses that was previously not typical to be provided. And then there's a number of other aspects to the rules that we can delve into further.
Okay. Steve, my question to you is that obviously Simon will go into the more rules as we proceed further, but do you think there will be any impact on the audits of alternative investment funds we do? Are there any relevant rules which are causing more cost to the fund managers, or the operational cost of the funds?
Well, first of all, you're going to have to do quarterly. You're going to have to issue quarterly reporting, right? So your reporting cycle is now going to be changed, right? So that's going to be the first thing. So from a fund admin perspective, you're absolutely going to see more stuff going on there. And then on our audit side, right, we're going to have to disclose all this stuff in the footnotes, and we're going to have to make sure that we have, again, whether it's historical or current, make sure that we have all the detail of any of those new agreements, and making sure that the calculations are now done, even tested more, because now they're going to be reported on different, on a quarterly cycle.
Anthony, do you think, is there a huge impact on the fund admin business? Do you think the fund admin costs may increase because some of the rules apply to the registered investment advisor?
Yeah, I mean, I think, I don't want to say time will tell. We as administrators, we're accruing expenses, and we realize and recognize pretty much all of the expenses that are fund level expenses. We do not report those on capital statements. So it's sounding like we're going to have to be reporting those on the monthly or quarterly investor statements, and again, more granular. I'd be interested in really knowing how itemized it has to get. So we already taking into account those expenses. Do I want to say we may have to increase our prices? I would like not to, because the reality is the industry is already tries to beat us down for pricing, and we want to try to stay as cost effective, especially when you're dealing with some of the smaller startup and emerging managers. Look, the larger managers, I'm sure they're gonna get dinged in terms of fee increases. They're the ones that probably can afford to pay the fee increases, although they probably don't want to. But it's gonna be tougher for the smaller guys in the industry to afford these type of expenses.
Awesome. No, I completely agree with that. That we don't need more inflation than we already have. That makes sense. Simon, my question to you is there any other rules which are effect as of now, or it will have an impact on the fund managers, registered and exempt reporting advisors both?
Yeah, there are some other restrictions that are applicable to all private fund managers. One is that certainly some fund documents allow or require the fund to cover regulatory investigations of the GP to the fund, and that would be an expense that is no longer allowable. Yep. Certain compliance expenses of the GP will no longer be covered by the fund. There's a nuance in many private equity funds where if there's a clawback on a performance or carry that the manager has received, that's net of the taxes that the manager has had to pay on that carry, and that now has to be clearly disclosed if that clawback is net of the taxes that the GP has paid on the carry. We had talked about the preferred treatment rule. Another aspect of the rules with regard to registered investment advisors is that now any pooled investment vehicle that's managed by a registered investment advisor has to be audited. There's no exceptions. So that we were discussing earlier, that will make launching smaller pooled investment vehicles, special purpose investment vehicles and the sort more difficult for registered investment advisors.
But these smaller funds are SPVs that still can be open under exempt reporting advisors, I believe. That is the best option for them.
Yes, if the manager is not, that's right. Those rules do not apply to managers that are not SEC registered.
Right. Okay. So, is there any transparency rules they implemented here, and we can discuss and along with those rules?
Yeah. So the transparency rules in terms of prior side letters and preferred terms, yeah, those once the rules go into effect, as I had mentioned, all existing and future prospective investors in the fund will have to be notified and all of the prior side letter agreements will need to be disclosed to those investors.
Right. So one of the question for any of you, that one of the rule which is grandfather says that if providing certain portfolio info negatively affects others, it must be shared with all investors simultaneously. Is this, can one of you give us an example how what do by this rule?
I mean, I'll just say, I mean, when you start to open up and show, let other investors know of, certain side letters. I think we were talking about this earlier. If you're when we were getting on a call before we got on this webinar, if you're a 10, 12-year-old fund and you offered a side letter to an existing, investor that was helping you sort of seed this fund. Now you have to disclose what those terms are, and this now can give sort of negotiating power to any new existing investor, which could, I don't want to say hinder the business, but it could to some points, because then again, we as an industry, fees are increasing in general, right? So now we're dealing with, on the admin side, if again, going back to us doing some more reporting, more detailed reporting, how will that affect the overall cost of operating the fund, right? And then, Simon, and you could touch on this too, it's, all of these managers now will have to go back and sort of revise the PPM to have all these new rules that are going to come into effect, because this now needs to be addressed and transparent in the PPM, right, Simon?
Yeah. So I would envision, everyone who's been managing a fund that's given preferred terms prior to the effective date of these rules will need to update the PPMs to, itemize out the preferred terms that they've given. Say perhaps, the date that the preferred term was given, the nature of the reduction in the fee. I can imagine a scenario where people will want to give some, granularity as to who the preferred term was given to, if it was a friend or family member or an early investor, to make it clear that, this was a one-time preferred term that, new investors in the fund shouldn't try to negotiate as well.
So how would they disclose these information to the other LPs in the fund? Are they going to mention in their investor letters, monthly, quarterly? Are they going to disclose on the investor statement? What kind of source or media would be appropriate for them to disclose these matters with the other LPs?
No, I think that's right, Mohammed. Every year they're required to disclose it to existing investors after the effective date. So, yeah, I could see that being, say, included in the last, NAV statement of the year, where every investor gets a chart of the new of any new preferred terms that were offered that year to a particular, I guess, not only offered but accepted or granted to any investor. And then as new preferred terms are granted, the PPM would need to be updated to reflect the date of that grant and the nature of the preferred term that was being issued. So I think, given the amount of ongoing disclosure and the amount of updating of documents that would need to occur, I think it's going to put pressure on fund managers to either completely eliminate side letters, or certainly reduce the frequency with which they're giving or granting those side letters. And I think the way, based on what we discussed before the webinar, it's likely that
That's everybody, right? Everybody's getting that. Not about that.
Everybody? That's that national
Everybody's
alert.
getting that from the government.
Yeah.
FEMA thing, right? I think it's some FEMA alert, right?
Yeah.
Simon, I had a question for you. In terms of, let's just say, what if I'm an investor in a fund and I don't want my information to be publicized to all the other investors? Like, I mean,
Yeah.
you're going to have to outline my name saying, right? Is it just investor A receives these terms?
Yeah, I'd expect it to be anonymous in terms of, yeah.
And I actually have another scenario along those lines, right? So obviously, if we're going to do this at year end, it's going to make its way into the annual financial, right? No question asked, right? But if you're reporting quarterly, and pick a quarter, let's say it's Q3, investors come, investors go, and you have some new side letters, some people dropped off. Would you want to report that in that quarter as well, or just totally wait for year end?
It's a good question. I suspect that because the requirement, as I understand it, is just year end.
Okay.
Everybody's going to want to consolidate it. Yeah.
Okay, let's go for a polling question, because otherwise people will not get the CPE. Simon, it was a tough question, but do you know what should be the answer here? Can you see the screen, and under what conditions can managers grant preferential redemption rights without adversely affecting other investors, A, B, and C?
So it would have to be disclosed. It would have to be disclosed to all investors simultaneously, not in my view contemporaneously with the grant of the, I'm sorry, preferred redemption rights. Yes. So I think the question is, would any preferred redemption right automatically disadvantage the other investors? And my sense, although there wasn't specific guidance, is that virtually any preferred redemption right there's a strong argument that it could disadvantage the other investors. So then it would need to be, I think the only scenario where I think, you'd probably be on pretty strong ground as a manager to not offer it to the other investors if, you waive the notice period. Let's say there's a 45-day notice period and somebody comes in 40 days, a couple days late. I can't imagine there's that strong an argument that materially disadvantages the other investors. But certainly if you waive a lockup or something along those lines, that would need to be offered to all investors simultaneously.
So a lot of people say B is the correct answer. So do you agree with them?
Yeah, I would agree with that.
Awesome. Okay, now more on the restricted activities, which we have already covered to some extent, right? As you already discussed, the clawback for taxes on the incentive fee, right? Also, there are some regulatory examination activities, these fees, expenses. As you mentioned, that the investigation fees are no more deductible at the fund level. So, so these are some of those activities. These are the disclosure-based exceptions. So it means we don't need to disclose those. No, we must disclose some of those. Some is we're just telling, I think, on all that. What is your take? Go ahead, please.
Yes, some of these would need to be disclosed, such as the reduction in the clawback for taxes, the charge for regulatory or compliance-based examinations. I believe there's a full-on prohibition for that.
Mm-hmm.
And then obviously the disclosure on expenses related to regulatory activities is a requirement to disclose that.
Okay.
So let me add, and again, let me just throw out a question here. So where it says non-pro rata allocation of portfolio investment related fees and expenses, right? Okay. In a very simplistic world, assuming you've got a master feeder, right? Because that would entail the same investment related portfolio, right? So at the two feeder levels, technically the management fees could be non-pro rata in each fund, right? Because they're not pro rata because you have different. So in a case like that, now you've got all this extra reporting to do here, right? Unless I'm misunderstanding the real basic concept.
This one, as I recall, and I haven't looked at it recently, but in certain funds, you couldn't over allocate expenses to a particular investor in a way that disadvantages other investors,
Okay.
even if that's fully disclosed. There's an outright prohibition on that, as far as I understand.
Okay, so right, so they're basically locking you into into a mutual fund box for this one line, for this one item here.
Yep.
Okay.
Okay, so these are the activities which require investors' consent. Certain rules are grandfathered, some are not. As you already discussed, investigations, right? So it means that if you get the investors' consent, then you can charge to those expenses to the fund, or what is Simon your understanding on that?
That's right. If the fund documents, which many firms use fund documents that allow the fund to cover that, if the fund documents disclose that, and obviously investors are consenting to that by executing the fund documents, the fund can cover those GP related expenses, except if the investigation results in a sanction.
Okay.
So in that case, the GP would have to either, would not be able, the GP would have to reimburse the fund for any, for the costs of the investigation that resulted in a sanction, as I interpret that.
Right, they're not going to let you take an expense for anything that could be deemed quote unquote, I don't want to use the term, but illegal or not allowed or anything along those lines, right? They don't want you to be able to get the benefit of the deduction, kind of like the IRS, right?
Exactly. Yeah.
So
That's the way.
it means manager can borrow from the fund though, as long as it is investor consent is obtained.
That's right. That would be allowable with consent. That's right.
Okay,
And
so
technically, they could borrow if the fund is being investigated, right? They can borrow. They could charge the investigative related expenses, but if they get sanctioned, then they can't. Then the GP would have to pay back the fund, right? Okay. Yeah.
okay.
Yeah. It's one nuance, and I'm just to dive in. Even if the fund documents allow for borrowing, this consent requirement would mandate, would further require the manager to get an affirmative consent before there's a borrowing from the fund. So I need to, tweak my response to make clear that a separate consent would need to be obtained from every investor.
Okay. So that's sometimes a lot of difficult work. Right? If someone
Yeah.
has 40, 50 investors reaching out to them and ask them that. It's a tedious, these are the tedious things to do, right? It's not easy. Okay, so I think now it's time for the next polling questions. this is a good one. Who puts together these questions really did some good work. And, probably we will get help from Simon on this, right? Simon, what do you think? A, B, C, which requires both disclosure and investors' consent?
The investigations,
Requires both.
having the fund cover investigations would require consent.
So majority of the people answer this question. So seems like we're doing a good job.
Well-informed audience.
Right.
I would have passed because when I took all my multiplication, not my multiple, my what do you call it? I would have chosen B for all of them anyway. That's what I used to do when I did my testing when I was younger.
And
right?
look
So,
where you are now.
I know. Tell me about it, Steve. Thank you.
Why were you picking B, not C and A? What's the reason?
You're asking me. Well, for me, I always write B. I always choose B. But no, I think, I mean, that's to Simon's point. I mean, you know, the investigation definitely would require both ends.
Okay, awesome. So managers with at least 1.5 billion in fund assets have 18-month compliance date for certain rules, and all other rules have 12-month compliance date. Managers with less than 1.5 billion in fund assets have 18-month compliance date.
Right.
So obviously, Simon, you have touched on that. If you can expand a bit here. So 12-month, 18-month rule and for different rules.
Yeah. So all of these rules that we've discussed for managers with less than 1.5 billion, they have these 18 months from the date the notice was filed in the Federal Registry, which occurred approximately two weeks ago. So yeah, I think certainly for those managers with less than 1.5, they wouldn't need to update their documents or begin disclosing preferred terms technically prior to that 18-month date. Although many may choose ultimately to start prior to then.
So what's your recommendation for registered investment advisors who are managing closer to 1.5 billion? And this is not at the fund level, this is at the overall investment advisors level. Right? What do you recommend when they should start operating their fund notes? And if we have already discussed or not, but I think the current MFA versus SEC, what are the options? What are the chances that MFA can win against the SEC?
Yeah. So agreed. And there are one or more suits against the SEC, most prominently the MFA has challenged some or all aspects of the rules. And it's difficult to handicap the likelihood that one of those suits will overturn some or all of the rules. We were discussing earlier, in my sense, having not spoken to any of the lawyers involved, is that the chance of the rules relating to SEC registered investment advisors and getting those overturned is not very great, given the authority of the SEC to promulgate rules under the Advisors Act. There may be more of a chance for the rules relating to non-SEC registered managers, but it's hard to say. My sense is it's better to assume the rules will go through and prepare accordingly, or at least plan accordingly. And but given the amount of time, you know, at least a year we have to implement these changes. Certainly, I think for SEC registered advisors, beginning to think through whether they plan on continuing to give side letters and preferred terms going forward is useful, and maybe considering baking in particular classes of fees into the document such that there's less room for negotiation and thereby less requirement to report those preferred terms on an ongoing basis may be useful. Certainly updating compliance manuals to address the need to offer preferred terms that disadvantage others in the fund, particularly around liquidity, is important. Yeah, I think discussing with counsel and your other service providers regarding, you know, the types of obligations these rules impose, starting those conversations, you know, sooner rather than later is important. And then the actual updates to the fund documents and can occur, you know, in the coming months or closer to when the compliance dates go into effect.
So, Steve, my question to you is, what will be the impact of these rules, effective date, and on the audited financial statements of the fund? Do we need to put more disclosures over there based on these rules, or what do you think? It is still very early phase of
Right. Well, for me, I at this point, I would think that we should start getting, you know, our schedule chart, whatever it's going to be, ready, especially for any funds that A, might meet these thresholds, and B, even if they don't, we might still want to be running it because you're going to have pre and post this day, right? And the reporting is going to be different, right? Pre this day, you're not going to have the detailed level of disclosure, but post you will, right? So you're definitely, your notes are going to expand. You're probably going to have some kind of schedule chart, whatever, a pen, however you know, might want to work it out. And it's going to have to directly correlate to the year-end statements that are being provided by the fund admin.
Right. Okay. So sooner or later, I think we will see the impact on those rules overall on our.
Right. And my suspicion is that if they're going to adopt early, obviously we're going to have to disclose that in the notes as well, that, hey, you know, these rules, you know, are not effective yet. We're adopting early, and, you know, based upon the early adoption, this is where we are.
Right. Yeah. So some are these record keeping, right? So one thing I think, Sam, you have already touched that the custody audit is no more applicable or no more desired. They need to go for an annual financial statement audits, right? So that will increase the cost. But overall, I think what is the document policy reviews within 60 days? Can you shed some light on this?
The document policy reviews,
Yeah.
compliance document review, or I'm not aware of that aspect of the rules.
Right. It is probably, I think, yes. I'm also not sure here. But anyway, we can get back to the attendees who are attending the event if there is any change. But I think this is more for Anthony, the quarterly statement, right? That's where you need to explain more, give more detail on that, right?
Yeah, I think, you know, we're we're going to have to show income before fees and then right, and then the fees, income after the fees. I think that's what we're going to have to report. As I mentioned earlier, like I said, we're already taking into account the expenses, and it's just how are we going to have to list all these line items in the in the statement for the investors to review. That's what I'm a little unclear of, and I think we'll know in 12 to 18 months what that's going to look like.
Right. Simon, I found this annual review. This is a documentation of annual review of internal control policies and procedures within 60 days.
I see.
All right, so that's got to be done within 60 days of year end, according to this. So one other quick question I kind of want to throw out there, and I don't know if anybody knows the answer or not, right? So theoretically, if the custody rule is going away to cure missing your audit deadline, right? What happens if you miss your audit deadline now? Right? What's going to be the quote unquote slap on the wrist for not getting the investors their financial statements by 120 days after year end for a regular fund, for getting fund of funds first? Or do we not even know that far yet? It is basically the question, right? It's TBD.
I think it would be the same 120 days, and the audit report would be within 120 days of the year end. But the point is, sometimes fund advisor may not be complied that 120 days requirement. I don't think so. There is a extension required from SEC for not submitting to the investor within 120 days. So, but usually when they come for the periodic review of the investment manager, they will look into those underlying financial statements, and if this audit report is not issued within 120 days, they will issue them the deficiency assignment. Is this right? That's how they.
That's right. I think the same implications are there,
Okay.
for delivering them late, delivering the report late. Yeah.
Okay.
So then other one I want to mention here, this is another requirement they have mentioned is fairness opinion and disclosure related to the secondary transaction for registered investment advisors. These all rules, all four, are applicable only to SEC registered investment advisors, not for exempt reporting advisors, all managers. So this is another opinion they are requiring, and its compliance date is 12 months. So 12 months, I believe, from the date. They need to get that opinion from the from independent valuation company. This is an additional cost, though, Simon, right? So this is a more work for a valuation company, which is good. But I believe they are asking if you are having that, you need to share that opinion with the investors, or get that opinion, or before closing the lab. But this is the requirement is 12 months on that. Okay. So
Yes. Yeah.
seems like there's a lot of additional burden on the investment manager, especially with the RIAs, I think. Other rules may not have a huge impact on the exempt reporting advisors or all managers, but I think this is definitely having a more impact on the registered investment advisors. So here, certain rules are grandfathered and don't apply to the funds that meet specific criteria. They are saying the specific criteria include commencement of operation before the compliance date. And compliance date means before 2 weeks or 3 weeks from now. Pre-compliance date, governing agreements and prevention amendment requirements. Grandfather rules includes restrictions on redemption rights of grandfather. Portfolio information distribution is grandfather. Direct borrowing by the manager from the fund is grandfather. Charging investigation related expenses to the fund are grandfathered. These rules, 4 areas are grandfathered. So let's go to the next polling questions, and hopefully within next 4 or 5 minutes, we will conclude this. Okay.
See, I would have got this wrong on my multiple choice exam because I would.
Yes. Glad you didn't pick B this time, otherwise you would be wrong. Comment. Okay, so the answer is 12 months. I think majority of the people have opted for 12 months. So good try by everyone. Okay, let's, before we conclude this, right, we need to, in order to get the CPs, we need to continue for another 3 months. And before I conclude this, so I would ask this question to everyone: what is the overall take from you to the fund managers who are listening to this webinar, and what the things they should be doing? Simon?
Yeah, no, I think it's really looking closely at the requirements that they're going to be subject to, of course, going forward, including disclosures of preferred terms, and the granularity of their quarterly reporting, and then certainly a review of their fund documents to see whether the fund allows them to engage in any of these prohibited activities, and potentially removing the ability to have the fund pay for investigations of the GP, for example, or certainly put policies in place whereby for the activities that require consent, obtaining consent before reimbursing for those type of expenses, for example. I think just a thorough review of how the rules can impact their fund and the ongoing reporting requirements, both from a fund administrator and auditor perspective, is going to be useful, and then potentially incorporating classes into their documents rather than issuing side letters. So I think just focusing on the implications and planning ahead is obviously what I'd recommend.
Very well said. Steve?
Yes, I was going to say, if I'd be getting ready. I'd be getting all my ducks in a row. Working under the premise that this is going to happen. I would be talking to my legal counsel. I'd be talking to my fund admin, and I'd be talking to my, my auditors, and getting everybody on the same page, so that when this time does come, we're not hitting, there's no hiccups. We're ready to go.
Awesome. Anthony?
Yeah, I was going to say the same thing. Pick up the phone, call your lawyer, ask them some questions. And if you don't have a good lawyer, call Simon. He's a great lawyer, right? I think you pick up the phone. I think you talk to your administrator. I think you talk to your auditor, as Steve had mentioned as well. This is sort of like uncharted territory, so we're kind of all in the same boat. But it's better to be proactive than not, right? So, I think the first conversation is with the lawyer though, right? And I think that they can give you the most color. And then you hope that you put everything in place for when the law is actually in place. And you know, as you guys said, just a little bit of a smooth sort of like transition.
Okay. No, I think obviously everyone knows Simon, but if you don't know, you can look him up at Rivers Wahab LLP, and based out of New York. And we have been working with Simon Rivers for the past 10 years, and I think every year is getting better and better. We're having a lot of mutual clients with EFSI and also with Rivers Wahab, and glad to see them growing with us. Okay, one last polling question, and then we will conclude this because this is the requirement. So give me 1 second. And
I might have gotten this one wrong.
Yeah, how do you get the middle one on this one?
I don't know. I've been trying to click it, but it's not working.
okay, awesome. So I think all the attendees who answered 3 out of 4 questions, our team will send you the CP certificate in next couple of days. So stay tuned. Thank you, Simon. You really helped and educate our attendees on this webinar. It was a great help. I appreciate that. Steve, thank you for your help. Anthony, thank you, all of you. Bye.
Thanks, guys. Appreciate it.
Guys.
Have a good one. Thanks, guys.
Okay, take care. Thanks, everyone.